Okay, we're going to go ahead and get started. Thank you for joining me today. It's Wednesday, June 17th, 2020, for those of you still keeping track. My name is Adam Kemper, and today I'm going to be talking about some of the legal implications for reopening your business. Certainly, this is a more exciting topic than ones which involve closing down your business. So thank you for joining me today. Next slide. So for those of you who don't know me, here is a copy of my profile, which describes what I do at Greenspoon Martyr LLP. Basically, I focus my practice on the area of labor and employment law, where I guide companies on a variety of workplace and human resources issues, basically everything from hiring to firing and everything in between. I also litigate workplace disputes and help companies with their workplace related audits. But my goal with every one of my clients is to avoid the lawsuit, to avoid the audit, avoid the related business disruption and expense associated with that. So that's part of what I'm going to be discussing today is, when you begin to reopen your business, or if you've already reopened it, what are some legal considerations to think about to avoid a workplace lawsuit or audit? Next slide. So before we get into the substance, I do want to do a quick poll to just see, how your business has been affected by COVID-19. There have been certain industries that have been able to withstand this pandemic, but most have been affected. So with respect to my audience tuning in today, I'm curious to see how your business has been affected. Get the results shortly. Okay. So a tie for business has decreased drastically versus generally business as usual. That's great. I think if, like I said, if you've been able to withstand this, bravo, congratulations. It's probably because you've been able to go to remote working, whereas certain industries just require their employees on site, hospitality, for example. So the first slide I have today is actually something that's being heavily overlooked during this pandemic. And I'm not getting a lot of questions about it, but I do think it's going to be a major issue going forward. And that is mental health issues arising out of this pandemic. In terms of when you begin to bring people back to work, you have to just be mindful that these may not be the same employees that you had pre-pandemic. Many of them have had their lives totally disrupted, whether it be financially or through their own illness, whether they had COVID-19, whether they know someone with COVID-19, or whether they just had some PTSD relating to watching too much Fox News or CNN. On a serious note, they could have some serious mental health issues. So there's been reports by the Kaiser Family Foundation that reported that as many as 50% of all Americans reported that they have suffered mental health issues relating to COVID-19. So if you're bringing back your workforce, cut that workforce in half and assume 50% of those, at least, probably that number's going up, have some sort of mental health issue relating to COVID-19. And the reason why I say that and the reason why I bring it up in a legal context is even the Equal Employment Opportunity Commission has recently come out with guidance and has acknowledged that pre-existing conditions have been exacerbated by COVID-19 and some of the stress-related issues. So it can become an ADA issue. It could be a situation where you have employees maybe reverting back to their old ways with drug or alcohol abuse. You may have drug or alcohol use on the work site, which you just need to be cognizant of. or you may have a lot of absences. Either way, it's that important now to just remember that you're bringing back humans and they've suffered through this just like your businesses have. And we need to get them excited to return to work. We need to empathize with what they've gone through. And we need to be cognizant of their mental health issues and perhaps some form of PTSD relating to COVID-19. So my recommendations around this is to offer some healthy incentives to keep the employees engaged. Figure out team building, which doesn't necessarily mean you have to physically be, within 6 feet, because we still want to maintain social distancing. But you can still figure out things, healthy ideas. Don't give somebody a gift card to go drink at a bar or something like that. Figure out, some community service project, for example, just to get them engaged, get them back to team building, maybe get them out in nature. And then the last thing to consider is, if you don't already have this, look into your EAP, Employee Assistance Program options, to see if you can provide your employees with a third party that someone who they can talk to or report any of the mental health issues that they may be suffering, in case that they don't want to bring it to your attention. They do bring it to your attention, just be mindful that there could be an ADA issue among other issues to consider. So you may want to touch base with me if I'm your counsel, or an attorney that you're comfortable with, if you're not sure how to handle that. Next slide. So is your business ready to return? A lot of companies just assumed they needed to race to the office or work site the second they got the green light from the government to reopen. And they may have not been ready to deal with bringing employees back, bringing, let's say, customers back if customers go onto the site. If they haven't been to the work site in many months, it's possible there could be some safety issues on the work site. And the point I want to make to that is that if you do get the green light from the government, you get a governmental order, that's the starting place. That does not necessarily mean that your business is ready, okay? Certainly don't reopen if the government has not given you approval, okay? And if you're not sure, review the local government order in place, okay? Talk to an attorney to determine whether or not your business is able to reopen with a work site. And I'm not talking about remote work. I'm talking about actually a physical workspace where people will be working together. Do you have a return to work plan in place? If you don't have a plan on how to reopen and how to implement safety protocols, how to bring people back, in my view, you're probably not ready to reopen. Because if you reopen and you don't plan for potential safety issues or issues that can pop up involving customers, let's say, or patients, then you can get yourself in a whole host of problems. So I do recommend that you actually sit down and put together a return to work plan, which addresses, how are you going to incorporate some of the CDC recommended safety protocols? How are you going to incorporate OSHA requirements? Are you ready to, if you haven't already been ready, are you familiar with the Families First Coronavirus Response Act and how that might apply to your employees? Have you physically checked the workspace to make sure that ventilation is okay, that your air is working, that there hasn't been something that has fallen in the workplace which could cause somebody to suffer an injury? I recommend you physically do an inspection of the workspace too, to see if there are any safety hazards in place. That should be part of the return to work protocol. And also, if you've been able to have some remote working capabilities through this, I would also recommend that you review to see how your employees actually fared during this. There's been reports that, and I was actually talking about this a year ago, that many employees are actually more productive when they're working from home or they have some form of teleworking. And the key with teleworking and remote work is to just continue to manage expectations and performance requirements. I mean, working from home, yes, you may have some distractions, but the key for the employer is that you have to manage expectations and you still have to enforce the same workplace rules and responsibilities. So if someone is doing a good job while they're working from home and they're abiding by your workplace policies and procedures, why do you need to bring them back? You know, is there really that much of a reward to bring them back just to have physical oversight to the employee? So if you are a business that can allow employees to work from home, in the foreseeable future, I strongly recommend that you continue to allow that in some capacity because we're far from done with COVID-19 from what it seems. And then once again, consider the risk versus the reward of returning to work in this climate. Depending on where you have businesses located, Florida, for example, where I'm based, has had record high cases this week. And many companies have gotten the green light. You know, we're under phase 2 for most of the state and phase 1 for the Miami-Dade, Broward County, Palm Beach County area. But many businesses have gotten the green light to reopen. And I'm already getting a lot of calls about employees with cases of COVID-19 and what do we do? Do we send all our employees back? Do we keep some? How do we handle this? Well, there's that risk, and it's still there today. You know, that risk may not be there for every company depending on where you're located, but that's why it's that much more important to evaluate all of these things. And I have a second poll question that I just want to ask you to see, you know, are you able to have remote workers in place, or do you have them? So we'll put that up in a second. So the question is, does your company require employees to work on site, or are they able to work remotely? I'm curious who, you know, if your companies will allow this or have these capabilities. Employees at my company work on site and remotely. That's the majority of the answer here. Okay, that's great. You know, I think in the future, we're going to see that to the extent practicable, and of course, there are certain industries which will never be able to go remote, but if you can work from a computer or a phone, I think what we're going to see is a trend towards allowing more teleworking capabilities for companies to reduce their real estate overhead, among other reasons. And because we have COVID-19, that doesn't mean we're not going to have a second wave or the next COVID come around and we may be dealing with this again. So next slide. So the return protocol, okay, now you've gone through some of the analysis. You know, it makes sense for your business to bring employees back. You reviewed productivity for your remote workers, or you simply just need to reopen because all workers are required on site. In addition to preparing a reopening plan, you need to have a return to work plan as well. How do you plan to bring people back? Who are you going to consider to bring back from, let's say, furlough status if they've been placed on furlough, or if they were working remotely, or if they were terminated? You know, who are you going to bring back and why? And what I tell my clients is, assume that this process of reopening, which we talked about, and bringing people back will be reviewed by a third party, whether it be OSHA, whether it be the EEOC for discrimination issues, whether it just be an aggressive plaintiff's attorney that's looking to get their client some money because that client's been out of work. Having this stuff in writing is not just a lawyer recommendation just to make you do unnecessary work. It's actually there intended to have a layer of defense for you. So it shows that you didn't just snap of the fingers, reopen or bring people back without considering the legal implications, that you've actually thought through this, that you've implemented the safety protocols, that you've considered all the legitimate business reasons why you need to reopen in the way you're doing that. And when you start bringing people back, it really needs to be business related. Okay. I know that there's a saying out there that, companies like to use a crisis to get rid of people maybe they've been meaning to get rid of. And that may be the case. But right now, especially with COVID-19, some of the race-related issues going on in our world, there is just heightened sensitivity to everything. And there's 51 million people out of work, at least. And people are going to get desperate to sue their employers. Don't give them a reason to sue you, okay? Spend the extra time now putting all your ducks in a row, because there will be lawsuits, okay? Hopefully you don't deal with them. If you do, we'll do our best to minimize the exposure. But I'm telling you, I'm seeing a spike already with the lawsuits because people are getting desperate and they are filing the lawsuits to try and recover some money. And a lot of companies screwed this up when they brought people back because they rushed through it. They said, I have a governmental order. I need to reopen. I need to start making money again. And I get that, okay? I totally understand that. I know it's been tough for businesses out there. But if you take some time to actually put together a work plan, to talk to someone like me about how to do this the legally compliant way, you can save a whole lot more time and a whole lot more money by avoiding the lawsuit, avoiding the audit, by not being in compliance, or by, skirting some protocols. So when you consider who to bring back, just be mindful that decision-making process can be reviewed for discrimination issues. Now, certain employees are not going to want to return. Okay, either because they like the new unemployment benefit that they get from one of the federal initiatives, or because they feel like they medically cannot return. Now, that brings 3 separate legal issues up in terms of the employees who either do not want to return or medically cannot return. With respect to the employees who do not want to return, let's say because of the unemployment. They want to keep collecting unemployment. It's easier to sit on their hands and collect unemployment than go back to work. Well, they may or may not know that they'll need to report that they received an offer to return to work and that they rejected it, and the unemployment agency may then cut them off. Okay, it's not your job to play unemployment agency representative and tell people that if they don't accept the offer that they'll be cut off. I'm not recommending that, but they will find that out sooner or later. And the key for you is to ensure that the offer to return to work is in writing and that the rejection is also in writing. So that if you have a reporting obligation to the state unemployment agency, you can show that you made the offer to the employee and that employee rejected it, and then the agency can go back and do what they want to do with respect to that employee. So that's sort of issue number 1. With respect to issue number 2, the employee who does not want to return because they fear COVID-19, okay? Well, look, there's going to be a lot of that. Okay, and this kind of goes hand in hand with some of the mental health issues. All you can do as an employer is make sure that you follow every possible safety protocol and be as flexible as you can possibly be. All of the guidance out there, CDC, OSHA, EEOC, all the guidance that I'm going to look at when I'm giving you guys advice it all says the same thing essentially, which is be as flexible as you possibly can be. And that's because if you're inflexible and you bring somebody back, and let's say worst case scenario, they get COVID in the workplace or it begins to spread in the workplace. Well, how you handled bringing the employees back and whether or not you followed the protocols, all of that's going to be measured in the workers' comp case, in the OSHA complaint, in whatever it is that you're dealing with as a result of how you're handling this. So if you tell the employee who's fearful of returning that you have everything in place to have a safe and healthy working environment, and you actually do, and as part of their job, it requires on-site work. It actually does need to require that, because if you have people working remotely and you're saying, no, you need to be on site, and they do the same thing, well, that's going to create a problem for you. But if you actually need people on site and that's part of their job responsibility, and you've done everything you could to make it a safe working environment, well, then you leave it to the employee to decide whether or not that employee is comfortable coming back. And if they say they're not, then they're not. But the key is to have that in writing and to have all the safety protocols in place, not only in writing, but implemented in the workplace. The medical issue, okay? Someone gets a doctor's note and it says, so-and-so has a pre-existing health condition. Let's say it's either been exacerbated by COVID-19 or they're particularly susceptible to contracting COVID-19 as a result of the pre-existing condition. Well, with these people, there's a number of issues here too. You have an ADA issue because that person may have a disability, and you have to possibly engage in the interactive process to see if there's an accommodation that can be reached. You may have a Family Medical Leave Act issue where they have a serious health condition, and that person gives you enough information for you to then offer the Family Medical Leave Act paperwork. And lastly, you may have a Families First Coronavirus Response Act issue where they may be entitled to leave under the FFCRA. The point being is this is not stuff that is like snap of the finger judgment calls. These are real legal issues that if you don't handle it the right way, it can get you into trouble with a lawsuit or an audit. So if you're just not sure, don't guess, okay? Get with an attorney that you're comfortable with. Let that attorney guide you on how you should handle this unique situation, because this is a unique scenario that we're dealing with. And the next bullet point is don't overlook the ADA and accommodation requirements. That sort of goes hand in hand with the last issue. But the point is, just because someone has a medical issue or they have COVID-19 or they're fearful of it, don't just immediately say, okay, I want nothing to do with you. I need to run my business. Remember that they may have an ADA disability. They may be entitled to accommodations. And more importantly, that this time period and how you handle employees, this is going to be reviewed with that heightened sensitivity that I was mentioning before. So just be mindful of that when you start making staffing decisions. Last bullet point is don't forget about the wage and hour requirements, okay? I know many of your businesses may have suffered through this, but business not doing well does not give you excuse to violate wage and hour requirements. Having employees work remotely does not give you excuse to violate wage and hour requirements. Or there's just being a lot, there's a lot going on with this and it's stressful. Also not an excuse, but I understand, I get it. So the point is, don't forget about wage and hour, because I've actually seen the biggest spike in wage and hour lawsuits because they're fairly easy to prove. And it's not a matter of, typically it's not a matter of if there's exposure, it's really like a matter of how much. If you get it wrong, even 1 week, even if you get 1 week wrong, there's a violation, there's exposure, it can create some damages for you. So the key is not to forget about that. Next slide. So you have the return protocol, you brought back your employees, you still need to think through what are going to be the safety considerations. If you've been paying attention to the CDC or watching one of these, Dr. Fauci or Fox News or CNN, it may be confusing because we've been going through this for a few months now and the guidance continues to evolve. Well, that's true. It does continue to evolve because we're still learning about the virus. We're still learning about how it is exchanged from person to person. But the key is to be on top of the latest guidance, and to make sure that you implement the latest safety requirements into your workplace. Because if you're working off some outdated concept, well, that can create an issue for you. So, for example, in the beginning, there was recommendations for people not to wear masks, and now they're recommended by the CDC. At least some cloth facial covering is currently recommended. So if it's recommended by the CDC, I'm going to recommend it. And I recommend that take a look, not every day or not every hour, but maybe once a week at the CDC guidance, because it is periodically updated. We'll send you a link to the most recent guidance for employers. But once again, you know, if you're not sure about the latest guidance, or if you're doing this right or wrong, confer with your attorney, okay? Because this is my job to stay on top of this, okay? And this is what I do. So I'm happy to guide you on the latest guidance from the CDC, from OSHA, from the EEOC. The EEOC just came out with new guidance a week ago. So I'm currently guiding companies on that. With respect to screenings, okay, this is an important issue too, because when you begin to bring employees back, you're essentially bringing people back who are going to the grocery store, they're maybe interacting with people, they're going to the places that are being reopened. They all present their own unique risks, and you can't possibly follow each employee and where they go and what they do, and tell them what they can and cannot do to an extent. So the best way to mitigate the threat of spreading a potential virus in your workplace is to have some form of screening, okay? Some companies are implementing temperature checks. There's some associated issues around that. So if you're gonna do it, we should talk about it and how you're gonna handle it. There's some wage and hour concerns around it too, if people are waiting in line an hour to get their temperature checked before they can work. So that's a whole separate issue. But that's one method of screening. You know, another method of screening is self-reporting, which I recommend to every company, that they have their employees self-report, not to the entire company, but let's say to a designated HR representative or someone in management that they're beginning to experience symptoms consistent with COVID-19, and at which point, that's when you need to immediately intervene and do something about it. It's not a situation where you can say, we'll get to it next week. So if someone has what they believe to be COVID-19, you need to act quickly, and you need to have a process in place on how to handle that and what you're gonna do if someone gets it, because they're showing up in the workplace right now. I've gotten several calls this week from different companies which have had employees in the workplace with positive COVID-19 results. And, you know, many of them are scrambling. They don't know how to handle this. So the key is, you know, to have the screening in place in addition to the other safety protocols. Make sure you enforce social distancing. Make sure you have signage in the workplace. Some people are visual learners. They want to see mask on face for them to understand that that's a requirement of your workplace. Some people want to see, you know, the sign that says social distance, 6 feet apart. If you're in the hospitality industry, make it very clear to consumers that they're to abide by your requirements as well. Because if they don't, they can potentially spread it to your employees, and then you have a workers' comp issue there too. So, you know, make sure that, that all the safety protocols are in place, that your employees are on notice of them. It's one thing to have them in place, it's another thing to actually tell your employees about them, and that they're to self-report if they have the symptoms to COVID-19, or if they're living at home with someone who maybe has a positive test of COVID-19 or has symptoms associated with COVID-19. You need to be mindful of that and make that as part of your self-reporting. And then the last bullet point is to update your safety policies and procedures. Again, this is not just some busy work that I'm recommending. It's actually there to help you, to work as a layer of defense, to put your employees on notice as to the new safety requirements, okay? If you haven't updated your safety policies and procedures, now is a good time to do so, because we're in the COVID age, I would say, for at the very least, another few months, probably a lot longer than that. I don't see the future. I can't predict how long it'll go, but your safety policies and procedures should be mindful of this, okay? Because it's very possible that this could be around for a while longer, and your employees need to know what they should and should not be doing. And it's there to work as a layer of defense if you're ever challenged on your safety issues in the workplace, to have those policies and procedures that you can show a judge, you can show OSHA, you can show whomever. So I'm not just saying this for busy work, I'm actually saying it because it will be helpful to you, okay? Next slide. So the Families First Coronavirus Response Act, if this is the first time you're hearing this, that's okay. But this has been a law, this is the law that's been around since March of this year, and it became effective April 1st. So the very first thing I recommend to you, if you haven't done so already, is to put up a poster of the FFCRA in a conspicuous location for your employees to see it. We're going to send you a link to that poster just shortly. And if your employees are working remotely, it doesn't help them if the poster is in a lunchroom that nobody can see. Okay, so email it to them. You need to ensure that everybody sees it. So if you want to do an acknowledgement form, even better. It's not required, but if you want to have them acknowledge that they've seen it, great. With respect to the actual requirements themselves, this is a brand new law. I took the time to learn it. It's not easy. It's not snap of the fingers, I got it. It actually does take some time to learn the requirements. There's two different forms of leave. There's payment caps to it. There's enumerated reasons to get the leave. There's a lot to take into account, and there's also anti-retaliation protection against terminating somebody for using leave under this. So if someone takes leave or gives you enough information to where they would be entitled to leave, and you fire them, even if the two aren't related, you can be sued for that. I've already seen the lawsuit come out. So the lawsuits are beginning to come in through violations of the FFCRA, and this is a law that's been around for 2.5 months. So learn the requirements, spend some time. If you're in HR and you're watching this either live or on the recorded version, spend some time, spend at least an hour or two learning the requirements. Take initiative, just like you would with Family Medical Leave Act situations, on learning the situations which would warrant leave. The employees may see a poster but not have any idea what FFCRA is or that they're entitled to leave. They tend to learn when they meet with their plaintiff's attorney what it's all about after they get fired. So you need to take the initiative. If you're in HR, you're in management, on offering the leave, okay? Ensuring that they are protected from not losing their job for taking leave, paying them appropriately during the leave, okay? And there's no reason not to follow this because it's reimbursable. You do have to pay on the front end for this leave. It is paid leave for every company with 500 or fewer employees. So it is a payment requirement. And I know a lot of companies are struggling for cash right now, but it is reimbursable from the government as a tax credit. So you want to make sure that you get the appropriate forms from your employees. If they're going to take leave, you need to have some documentation surrounding it so that you can submit that to the IRS when you go for your reimbursement. It's not just to be an annoying employer, it's really there because you need it to get the reimbursement. And also because your employees need to be telling the truth too. Offer flexible working arrangements. I mentioned this before, and I just want to reiterate it because it is literally in every piece of guidance. So don't just require on-site work if it's not necessary. Be flexible for the foreseeable future. Try and be flexible. Understand that employees are fearful of this. Understand that they don't know what the future holds with this. I mean, this kind of is a combination of issues with the flexible working arrangements. But it's also within the FFCRA to be flexible with your employees. Now, keep one thing in mind. If someone does take leave under the FFCRA, in order to be eligible for paid leave, they need to not only meet one of the designated reasons for leave, but they also need to show you that they cannot work remotely during that time. So they can't just be at home sitting on their hands if the computer is right in front of them and they can work for you. It needs to be a combination of not only meeting the enumerated reason, which is having COVID or taking care of somebody that has it or taking care of a child that's been displaced due to COVID-related reasons, but they also need to show that they cannot work during this time. Whenever you're in doubt, just confer with your attorney. It'll be a quick call. I know this law very well. I've been talking to a lot of companies about it. Many still don't know about it, but it is legally required that if you have 500 or fewer employees, that you're mandated to comply with this. Not only have the poster, but to offer the leave to ensure that you don't retaliate against your employee or interfere with their use of FFCRA leave. So learn it and confer with an attorney when you're not sure about whether or not it applies. Okay, the next slide, please. So that's all I have for my substance, and I encourage you to submit any questions that you have for me. Now's a good time to get some guidance on something that's been difficult for you in the workplace relating to COVID-19. Feel free to ask away, and I'll just wait for a couple of seconds. Okay, so we already have two questions. Thank you. But please, as I go through these, now's the time to ask your questions. And if you're watching the recorded version of this, feel free to send me an email or give me a call if you're unable to get your question addressed now, or if you're just not comfortable asking in this setting. So the first question is, do we have to bring employees back who were terminated during the shutdown, or can we consider hiring others? That's actually a really good question because it goes into the analysis of who to bring back and the decision-making process surrounding that. So if you've terminated employees, you've laid them off due to COVID-related reasons, and you you want to consider other people instead of the people that you've laid off, well, just assume that that process is going to be reviewed. Okay, assume that the people that you've selected in lieu of the ones that you've been let go, there needs to be business-related reasons for that. It can't just be that you favor a certain protected characteristic over the other, because that's discrimination. So I would say that those decisions will be scrutinized even further, because you could very well just try and call back the people you let go versus considering new people. So there is some risk around it. You can do it. I would just be mindful of how you do it and make it a part of the bringing employees back protocol that we talked about earlier. So the second question is, if an employee says that he or she does not want to return to work for fear of contracting COVID-19, can we terminate the employee? I'm getting more questions here in the chat too. Okay, if an employee says he or she does not want to return to work for fear of, can we terminate the employee? I kind of talked about this before. You should not rush to make any decisions when someone is showing a sign of fear. There could be an underlying medical reason for that. If it relates to just wanting to sit on their hands and collect unemployment, I gave you the answer to that. If it relates to someone that has a pre-existing health condition, there's a whole host of legal issues to consider before you sever ties. If someone is just fearful for contracting COVID-19, and I said this earlier, and you've gone through all of the safety protocols to make sure that you have a safe and healthy working environment, then you leave it to the employee. You say, look, I've done my part. I'm legally allowed to reopen. I need you here because it's an essential work function to work on site. And I've done everything I could. So I'll leave it up to you whether you want to work here. And the offer remains for you to stay here. And if they reject the offer, well, that gives you the answer. Okay. I have another question. Hey, Adam, can you dive a bit deeper into FFCRA and what are some of the main points of it? If you look at the poster that we're sending to all attendees, it's actually a pretty good summary of the basic requirements. So at the very least, I would say study the poster, because this is the document all your employees are supposed to receive. And if you pull up the poster itself, I don't know if we can show it on the main screen. If we can, that'd be great. If not, then I just recommend everybody take a look at the poster. But basically what it does is it entitles employees to 2 weeks of paid leave under what's called FFCRA, or the Emergency Paid Sick Leave Act, if they either have COVID-19 or they're dealing with some type of isolation order or quarantine order related to COVID-19, they have symptoms related to COVID-19, they're caring for somebody else who has COVID-19, they're caring for their child who's been displaced due to COVID-19, or they have symptoms which are similar to COVID-19 but don't actually have COVID-19. Under those circumstances, they're entitled to 2 weeks of paid leave, okay? And depending on which of those reasons, they can be capped at either 200 a day or 511 a day. And the poster itself does a good job of just showing you the pay caps for the enumerated reasons. Now, under the EFMLA, which is the Emergency Family Medical Leave Act requirements, also part of the FFCRA, you can get an additional 10 weeks of paid leave, 12 total, if it's the scenario where you're caring for your child due to, let's say, school closures or childcare centers being closed due to COVID-19 related reasons. So you can get a maximum of 12 weeks of time off if your kid has nowhere to go due to COVID-19, and it's all paid. So in addition to that, I would just be mindful of the anti-retaliation requirements, some of the remedial schemes if you do violate it, because right within the poster, there's reference to the Department of Labor. So if a company doesn't follow the requirements of this, employees are advised to call the Department of Labor to investigate and enforce the requirements. And they can also sue you outright. And there's many lawyers out there that would love to take this case right now because of the hypersensitivity I talked about. It's an easy violation to prove. But it's also very easy to follow as well. Once you just learn the poster and maybe talk to me for a little bit if you have any more questions. But I hope that helped a little bit. I think we had one more. Okay, so we had one more question here. How much notice, and if you do have a question, if you could type it in the Q&A. Let's see. Oh, here we go. Answer live. Okay. How much notice are employers required to provide employees on their return to work policies? Well, the answer is there's no legally required amount of notice. They can say we're reopening tomorrow. We got the green light from the government. Come back to work tomorrow. So there is no legally mandated notice requirement if an employee is on leave for that time. However, let's be respectful, let's be mindful of everyone's circumstances and try to give as much notice as you possibly can. That's what I recommend. And certainly make sure, the whole point of this presentation is to make sure that you're ready to reopen as well. Okay, another question. Thank you for all the questions, by the way. Okay, another question is, earlier you mentioned keeping everything in writing in terms of protection. how airtight is an email trail in terms of having these encounters in writing? I don't know specifically what you're referencing, but what I can say is writing is writing. You know, I don't like text messages because they tend to disappear after 30 days automatically. Emails don't. Emails remain. So emails are okay. But if the question is relating to, you know, a discussion with the employee about returning to work, email is fine. You know, that's I don't recommend you do snail mail or you know, physical letters, because that'll just take too long. So emails are definitely fine for that. Okay, thank you for all the questions. Another one is, when a professional caregiver learns that their in-home client has developed COVID-19, are they obliged to return the case to the case? When a professional caregiver learns that their in-home client, are they obliged to return to the case? Are they obliged to continue working? Well, that's a safety hazard, I would say. I mean, it's kind of like a frontline worker scenario, where you have nurses and healthcare practitioners that are dealing with people that are ill and people that have COVID-19. You know, that this kind of is a hybrid scenario, because this, you know, this is a caregiver and may not be someone who is a healthcare worker. So I would say that that's something that you know, it's going to be a close call on whether or not they should be taking care of the person if the person has contracted COVID-19. At the very least, they should be given the option. The caregiver should be given the option so that they're not forced to work in an uncomfortable situation if they're not comfortable with it. If they are comfortable with it, that they be provided, or that they're recommended to, you know, have every possible safety, you know, safety device available, PPE, et cetera. And we're talking about caregivers, I mean, if someone is taking care of somebody that has COVID-19, that person probably should be in the hospital, depending on how serious the case is. So, good question though. One more question I have here. Let's see. Is it fair for employers not to cover cost of living raises on future contracts due to current COVID situation? Is it fair for employers not to cover cost of living raises? You know, that's not really what the focus is of this discussion. You know, contracts are bargaining, or they're bargaining devices. You know, both sides have the opportunity to bargain for what they want versus what the other side will give. So I don't think COVID is going to, you know, it may or may not affect that particular piece of bargaining, but good question. Thank you. Let's see, do I have any more? Okay, I think that's it, unless anybody has any last minute questions. I want to thank you all for tuning in to this. And if you're watching the recording and would like to ask me any questions, here is my contact information, or if you want to discuss any of these matters further, feel free to send me an email, give me a call. Hope you all have a wonderful day and stay safe. Thank you very much.